My name is Michael Kennedy, and I am an attorney and senior partner at Estelle and Kennedy, a full-service law firm with offices in Upland, Los Angeles, and in Mission Viejo, California. Today I will discuss laws governing discrimination, harassment, and retaliation in the workplace. This discussion is not intended to be legal advice for any particular case, but is intended as general information for public use. Many businesses, job applicants, and workers will agree that a favorable working environment is important. Unfortunately, however, there are times when the relationship sours, either because an employment offer was not extended or after an offer has been made, the work relationship deteriorates. Sometimes the reasons for this breakdown may be for legally justifiable reasons. Unfortunately, there may be times when this breakdown is due to unlawful conduct, including discrimination, harassment, or retaliation. Now, there are state and federal laws that govern the obligation of businesses and the rights of workers in cases where discrimination, harassment, or retaliation has been alleged. Under California law, for example, the Fair Employment and Housing Act, or FEHA, prohibits discrimination, harassment, and retaliation. The law also requires that employers take reasonable steps to prevent and correct wrongful, harassing, discriminatory, retaliatory behavior in the workplace. In addition, California regulations require employers to develop and distribute anti-discrimination and harassment policies to its employees. Unlawful workplace discrimination occurs when a business uses a specified, prohibited basis such as gender, age, race, religion, or disability to negatively affect the terms and conditions of the employment. Examples of such discrimination can include, but are not limited to, disciplining, terminating, denying promotions, and giving disparate wages to a worker because of these categories. California state anti-discrimination laws are codified in the Fair Employment and Housing Act, or FEHA. Federal anti-discrimination laws are codified in various statutes, such as Title VII of the Civil Rights Act of 1964, which covers race, color, religion, sex, and national origin, the Pregnancy Discrimination Act, the Age Discrimination in Employment Act, also known as ADEA, ADEA, and the Americans with Disabilities Act, also known as ADA, which governs claims regarding disability discrimination, and Genetic Information Non-Discrimination Act, also known as GINA, which prevents discrimination from health insurers and employers. It is also important to remember that California anti-discrimination state law is more expansive than federal law and covers more categories. For example, California also deems protected categories to include gender identity and expression, marital status, and certain issues regarding one's criminal conviction and/or arrest history. Unlawful workplace harassment on the basis of a protected category, such as gender, age, race, religion, or disability, typically will consist of conduct that conveys hostility or denigration because of one's protected category that creates a hostile, offensive, oppressive, or intimidating work environment and negatively affect the terms and conditions of the employment. To be actionable, harassment must be frequent or severe. A single offensive comment or stray remark will usually not meet this test. Unlawful workplace retaliation may occur if an employer takes some action to punish a worker for engaging in a protected activity, such as challenging unlawful discrimination or harassment or reporting illegality. This may include taking action against a worker for filing a workers' compensation claim or filing a complaint with an administrative agency such as the Department of Fair Employment and Housing or the Equal Employment Opportunity Commission, otherwise known as the EEOC, or a wage claim with the Department of Labor and Division of Labor Standards Enforcement, otherwise known as DLSE. There are strict deadlines that a complainant who wishes to sue a business for discrimination, harassment, and retaliation must adhere to, or else that person risks being forever barred from filing a lawsuit for these claims. Often complainants may wish to seek both state and federal remedies, so it is important to adhere to both deadlines. For example, before being permitted to file a lawsuit against an employer based on California state anti-discrimination, harassment, and retaliation laws, the complaining party, job applicant, or employee must file a complaint with the Department of Fair Employment and Housing, also known as DFEH, within 1 year of the alleged violation. If the complainant wants to file an action under federal anti-discrimination law, he or she must file a charge with the Equal Employment Opportunity Commission, also known as the EEOC, within 180 days of the alleged violation. However, this deadline for filing a claim with the EEOC is extended to 300 days for complainants in California because the EEOC shares administrative responsibilities with the Department of Fair Employment and Housing, a state agency. After a claim or charge has been filed with the state and federal agencies, the complainant will at some point receive a right to sue letter, which is the complainant's authorization to file a lawsuit in either the state or federal court to assert claims against the business for discrimination, harassment, or retaliation. Under California law, a complainant will have 1 year from the date the right to sue letter is issued to file a civil suit. In contrast, an individual will have only 90 days from receipt of a right to sue letter from the EEOC to file a civil suit for claims under federal law. The failure to timely file a lawsuit on or before these dates may bar the complainant from filing a lawsuit based on claims of discrimination, harassment, or retaliation. These are just some of the considerations that both businesses and workers need to consider when trying to assess their respective obligations and legal rights under state and federal laws concerning discrimination, harassment, or retaliation. Estelle and Kennedy is here to assist both businesses and individuals navigate this particular area of law. Thank you.